Hi, Rob Wells here from the Law Office of Robert M. Wells. Our office specializes in helping out landlords deal with their landlord-tenant situations and problems. In this video, we're going to talk about what is the Tenants Protection Act, and as from a landlord's perspective, why should you care? Before I begin the video, landlords, if you're concerned about whether or not your tenancy is subject to the Tenants Protection Act or need more information about what that is, please feel free to contact us down below and we can help you out. So let's begin. So what is the Tenants Protection Act from the landlord's perspective, and why should you care? Well, the Tenants Protection Act of 2019, also known as AB 1482, was a California statute that was passed in 2019 to regulate how landlords can terminate their tenancies on certain residential tenancies, and also how a landlord can increase rent. And regulate the statute also regulates how much a landlord can raise the rent each year. So in a nutshell, just kind of as a generality, for example, landlords that are subject to the act are predominantly those that rent multifamily properties to tenants or have multiple tenant situations at their property, such as a landlord that rents out like 4 rooms in their single family home. That they could be subject to the Tenants Protection Act. It generally happens like this. Tenants will acquire Tenant Protection Act protections after they've lived at the property for at least 12 continuous months, meaning you've signed a 1-year lease, for example, your tenants lived there for a year. They're going to be protected unless a landlord has a specific exemption within the civil code, and there's 9 current exemptions right now. Oh, and I also should mention too that as of January 1st, 2022, mobile home tenancies, where landlords rent out a mobile home, could be subject to the Tenants Protection Act as well too. So back to my point of a tenant that's lived at a property more than 12 months can acquire Tenant Protection Act protections, or if there are multiple tenants, they generally have to live there 12 months or more, all of them, or one tenant has to live at the property for 24 months or more. If you're subject to the act, the law states that you can only terminate a tenancy or basically evict a tenant for one of 15 legal reasons, and they're prescribed in the civil code. An example of one would be a tenant not paying their rent is cause, or a tenant not complying with one of the lease terms of their agreement is also cause under the Tenants Protection Act. Those are the kind of things that, the tenant has to do something wrong, or there's 4 reasons where, a tenant doesn't have to do anything wrong, such as a landlord just pulling their property off the residential rental market, for example, or they're going to move into their own property. So those are some of the exemptions and some of the causes, but there are many more. So that being said, besides regulating how a landlord can terminate or evict a tenant, it also regulates how much a landlord can increase the rent on a tenancy. And generally speaking, landlords are regulated to raising the rent only by 5% plus the change in CPI. That's based on the Consumer Price Index published by the federal government. And it's a little bit complicated how that changes each year. That's a topic for another video. So landlords basically are capped at raising the rent based on this 5% plus whatever the change in CPI is for the year that the rental increase is going into effect. So those are the 2 major regulations that a landlord must face if they're subject to the Tenants Protection Act. In separate videos, we'll cover each specific no-fault cause or just cause in the civil code, as well as talk about the exemptions. So again, landlords, if you have a tenancy where you're not sure if you're subject to statewide eviction and rent control prescribed under the Tenants Protection Act, please feel free to reach out to us. We can help you out. Until next time, we'll see you later. Take care.